University in Warsaw. In addition, I am a prosecutor and director of the Office of Informatization and Analysis of the National Prosecutor's Office in Poland. I wish to warmly welcome you to the first scientific seminar entitled Current Legal Regulations and Research on Artificial Intelligence in Poland and Hungary. The main objective of the seminar is to identify the current regulation of artificial intelligence in Poland and Hungary. In addition, the aim is to review the state of research of the regulation of artificial intelligence at national level, both in Poland and Hungary. We have 6 members of the legal aspects of artificial intelligence team presenting their papers at today's seminar. For the first speech, I would like to ask Mr. Zbigniew Więckowski to present a paper titled Artificial Intelligence Strategy for Poland. Zbigniew Więckowski is an assistant professor at the Institute of Legal Studies at the Cardinal Stefan Wyszyński University in Warsaw, the Civil and Private International Law Chair at the Law Faculty. He conducts research on the civil law, pharmaceutical law, intellectual property law, and the law on new technologies. Moreover, he is the member of the working group on artificial intelligence affiliated with the Prime Minister. Professor, the floor is yours. You can share your screen.
Thank you very much. Thank you for this short introduction. And I will share my screen, and I will be happy if somebody could confirm that my presentation is visible. Is it visible?
Yes, the presentation is visible.
Okay, thank you. Thank you. Okay, so for today, I prepared a short presentation titled AI for Poland. And the aim of my presentation is to shortly present the Polish strategy for the AI. On the 12th January 2021, the Polish Council of Ministers published the Policy for Artificial Intelligence Development in Poland from 2020. And I will be calling this paper, this document, as a AIPL or AI strategy for Poland. And this document is accessible, both Polish and English version, on the website visible on the screen. The AI strategy for Poland,
especially... Excuse me, Zbigniew, could you turn on the slideshow, because we cannot see that the slides are not moving. So something is wrong with sharing your screen. We see the presentation, but not as a slideshow.
Okay, so let me start once again. And now, it's better, or is it the same?
It's the same. So if we cannot change it, remember to change the slide on the left side of the...
Okay, I will.
Okay. Thank you.
Okay, what's a pity. Maybe next time will be better. So just to shortly describe the document, is this Polish strategy. For the aim for this strategy is to highlight the opportunities that AI offers to Poland's economy. Why is AI important for us, for Poland, I think is the same for Hungary and for this part of the world. First of all, this is a great opportunity for our societies, for our companies, firms, and for our economy. Secondly, new solutions, services have been developed and implemented only recently, so it's the best time now to join this journey. And thirdly, the Polish society and other societies from the Eastern and Middle Europe have a chance to stop being just a consumer of others' inventions, and we can become a country of inventors and creators of new solutions. This document pointed some priority sectors for AI development, and those sectors are public administration, construction, cybersecurity, energy, retail, healthcare, industry, agriculture, transport, and logistics. And what is interesting that our strategy, Polish strategy for AI, sets out a number of activities, and those activities were divided into three time periods. Some activities need to be completed until 2023. Some activities have longer period of achievement, and it is until 2027. And some activities have long period of time, so there are long-term goals, and this kind of activities should be achieved after 2027. And those activities were showed on the six strategic areas for development AI in Poland. And those strategic areas are society, innovative firms, science, education, international cooperation, and the public sector. And of course, I will not present all activities that need to be concluded or need to be taken. I will show you some, just to have a big picture what kind of activities the Polish government needs to want to start and conclude to achieve their goals. Speaking about first strategic area, AI and society, I would like to concentrate on the short-term objectives. And as you see, this kind of objectives are especially concentrated on the social aspects of AI. So first of all, our government needs to concentrate on the effective prevention and mitigation of the negative consequences of the development of AI, especially for the labor market. I think we should pay attention to this next red statement, launching campaigns to prepare society for changes. I believe that every kind of new technologies, equipments, or new kind of society management like AI could install need some campaigns to prepare society for change. So this is good that our government needs think about this kind of activity, and making Poland an attractive country for highly skilled AI experts. I think that Poland and Polish government thinks not only about Poles, but Polish government thinks about people and societies outside Poland, to invite them and to work for Poland on this AI economy industry. Medium-term objectives are especially analyzing and eliminating legislative barriers and administrative burdens for artificial intelligence startups, and in medium-term period, preventing unemployment for disadvantaged groups. Long-term goals are as you see, showed as Poland as a leader of the biggest beneficiaries of the algorithm economy, Poland among the top 10 countries in the AI Readiness Index, or Poles are prepared to critically use AI-based system. Truly speaking, I'm not optimistic speaking about this short period of time, truly speaking, because Polish government want to achieve this goal until 2027. So I believe it can be rather difficult to be among the top 10 countries in the AI Readiness Index, but nevertheless, we should start now, at least to be at the maybe not at the top, but to be one of the countries that AI society and AI possibilities are achievable. AI and innovative companies is another strategy mentioned in the Polish report. And here, short-term objectives are increasing demand for AI-based solutions, increasing the number of Polish state-owned companies implementing AI projects, or creating knowledge bases and developing good practices. Medium-term objectives increase the number of companies providing AI-based solutions, or increasing the competencies of Polish managers in the field of AI. Long-term goals, as you see, as optimistic as for the previous strategy sector, Poland has at least one globally recognized Polish company that operates in the field of AI, or Poland is among the top 25% of economies producing innovative AI-based solutions. We will see if Poland could achieve this kind of goals. AI and science, disseminating practical knowledge concerning AI in the short-term period, and development of projects tailored to Polish problems and challenges. This is something interesting, as you see, using AI, for example, for some kind of translation. Medium-term objectives, establishing ties between academia and business, increasing the attractiveness of Polish universities, and internationalization of higher education. Long-term goals, Polish universities are internationally competitive. Polish scientists are often nominated for the most important industry awards, and increasing the number of patents. AI and education, short-term objectives, dissemination of practical knowledge, support for the development and development of educational materials for the younger groups of students, pupils, and this basic level of education. Medium-term objective, implementing a comprehensive educational curriculum on AI in primary and secondary schools, and boosting the image of Poland as an attractive place to acquire qualifications. Long-term goals, Poland is the European leader in education in AI and other digital technologies and secondary school level, and what is very interesting, Poland co-organizes mathematics and AI competitions at the European and global level. AI and international cooperation. So this is the next priority sector. Short-term objectives, creating an environment that fosters international investment, strengthening cooperation within the EU, NATO, V4, and the United Kingdom, Switzerland, Norway, identifying priority areas where Poland has a chance to be internationally competitive, medium-term objectives, coordinating Polish action plans within broader European and international initiatives, promoting EU international funding programs. Long-term goals, Poland has innovative AI centers of excellence and testing. Poland has a long-term strategy for AI development. And the last sector is AI and public sector. As you see, short-term objectives, the list of the short-term objectives are the longest. So let me just pick three of them: opening public data, using AI-based solutions for continuous monitoring and improvement of the environment in Poland, or exploiting the research potential of medical data to improve citizens' health. Medium-term objectives connected to this data subject. Public data is available and widely used. Poland is one of the most active countries in developing ethical use of data. And long-term goals, Polish public data is accessible and easy to use for citizens, researchers, and industry. Polish diplomacy promotes Polish AI business and scientific centers. The role each year, the Foundation of Digital Poland presents some kind of report on the state of art, state of Polish AI. And last year, this Foundation Digital Poland published State of Polish AI 2021. And authors of this report commented this strategy for Poland, and what they mentioned. AI policy is still relatively unknown by the community. Thinking and speaking about community, I think about CEO, CFO of AI companies that are in Poland, that operates in Poland. So CAO were asked about some aspects of AI in Poland, about AI policy, AI strategy, and this report is full of answers coming out of this CEO, CFO, as I said, managers from the AI companies located in Poland. And what did they say? They note that AI strategy for Poland lacks clear goals, KPIs, clearly assigned responsibilities, and a financial commitment. So what they recommend is to better promote abroad Polish AI companies, to give better access to good quality public, to give some tax incentives, to make more coding classes in schools, and to have better, to have research grants more accessible. Currently, as they mentioned, the AI policy has some flaws which should be fixed. In particular, a roadmap for artificial intelligence event is needed. So they suggest that Polish government should organize a big event like our government used to do it in the past. Polish government should allocate responsibilities. So all initiatives mentioned before in this report should have their owners. There should be clear KPIs, so progress should be measured by clear and transparent KPIs, and need to be a prepared financial budget, because now many initiatives lack budgets. Long-term development of AI requires stronger research teams. So the community of AI managers recommend to create leading event, to promote cooperation, and to increase salaries at the Polish and not only perhaps Polish universities. Speaking about Polish AI ecosystem, it's interesting to notice that in Poland, the function of Ministry of Digital Affairs has the prime minister. Polish government opened and has the official AI website, official portal. As you see on the right side, is a part of this website, unfortunately, and I think that this should be immediately need to be changed. Unfortunately, the content is in Polish only, and this is not only my opinion that this is something wrong. Preparing for this presentation, I found an opinion of one of the researcher, Alex Molcał. He said that attempting to understand Poland's current AI strategy was harder than expected, partly due to the Polish government website only being in Polish. So I think that this first recommendation to have the English version of the official website of the AI prepared in English as well. Thank you for listening. My presentation will be available. Sorry for speaking so fast, but I wanted to not to say too long, because I knew that my time was only 15 minutes. Thank you.
Thank you very much for your presentation. I wish to invite anyone to ask questions by using the chat section on the platform. So are there any questions to our speaker? I don't see. So we can move forward. For the second presentation, entitled Artificial Intelligence Needs in Poland, I'd like to ask Mr. Rafał Wielki. Rafał Wielki is an assistant professor at the Institute of Legal Studies at the University of Opole. He specializes in forensic science, analysis of evidence, and analysis of information, mainly intelligence analysis, in a work of law enforcement agencies. Professor, the floor is yours. I see that the presentation is visible, so the floor is yours.
Okay, thank you very much, and thank you for this information about my presentation that is visible. To your colleagues, dear guests, today I would like to present my topic, artificial intelligence needs in Poland, and I would like to give you a little background about implementation of artificial intelligence in our country. So we're going to focus on some social needs, some economic needs, and of course some legal needs. As Zbigniew mentioned, the main document is a policy for the development of artificial intelligence in Poland from 2020. It's a document that was drafted in line with the activities of the European Union, but also it's a result of adoption of strategic documents by international organizations, of which Poland is a member. Maybe it is worth mentioning that our artificial intelligence policy takes into account the objectives that were defined in some other strategic documents, like Public Data Opening Program, Strategy for Responsible Development, From Paper to Digital Poland Program, Dynamic Poland 2020, Strategy for Innovation and Efficiency of the Economy, communication of the European Commission Coordinated Plan on Artificial Intelligence and position of the Vice Group on Artificial Intelligence. Also, there were taken into consideration recommendations of the high-level expert group on artificial intelligence to the European Commission. That was ethics guidelines for trustworthy artificial intelligence, recommendations on policy and investment in trustworthy artificial intelligence, and recommendations concerning the management of trustworthy artificial intelligence and the strategy of Polish foreign policy. Also, we had a memorandum on development of artificial intelligence in Poland. As Zbigniew mentioned, we have 6 main areas, so I won't tell about this, and I'll try to focus on some other issues related to artificial intelligence policy and needs in Poland. It's worth mentioning that our policy doesn't cover any state activities in the field of national security or defense, because there is an assumption that the cooperation of the civilian sector with the military sector will be present, but in all areas useful for the needs of national defense. It will be connected to civilian sector. Those priorities were set in national security strategy of the Republic of Poland, but maybe situation can change because of Russia-Ukraine war, and maybe those priorities will change. But there is an assumption that Poland is in a convenient position because our economy is based on industry. So there are lots of benefits from implementation of artificial intelligence, but it's also worth to focus on solving some legal problems. What solving legal problems should consider? First of all, it's building a culture of cooperation between the public and private sectors, because there is a lack of this. Also, we want to focus on development of citizens' creativity by strengthening the labor market, development of central coordination mechanism for public initiatives on artificial intelligence and technologies, supporting cooperation between academic centers and business. Also, we're thinking about active cooperation in the European field in the development of trustworthy artificial intelligence, increasing transparency of artificial intelligence systems, protecting individuals against violations of their rights and freedoms. Also, supporting cybersecurity aimed at combating disinformation. That is very important, especially for me. So this was a presentation of the general needs for the implementation of AI, but now I would like to give an insight on the needs related to my research for this project. So I'm thinking about use of artificial intelligence in law enforcement and criminal justice. There is a very important this point of view document that is a proposal for regulation of the European Parliament and the Council, laying down harmonized rules on artificial intelligence and amending certain union legislative acts. It's called just as an Artificial Intelligence Act, but this proposal gives some challenges in criminal law. Why? Because the Commission is proposing new rules to make sure that artificial intelligence systems used in European Union are safe, transparent, ethical, under human control, and therefore there is a proposition to categorize by risk those systems. And as we can see, there are 4 levels: unacceptable risk, high risk, limited risk, and minimal risk. The best thing is to focus on unacceptable risks. Why? Because from point of view of criminal justice, policing, law enforcement, we're talking about artificial intelligence systems that are contrary to the European Union values, like respect of human dignity, freedom, equality, democracy, rule of law, fundamental rights, data protection, privacy. So this means that this proposal gives also the catalog of prohibited practices in the field of artificial intelligence. That includes, for example, manipulating people with some subliminal techniques that act on subconscious of people, of some certain groups of people, such as children, people with disabilities, mental disorders. In addition, there is a proposition to prohibit use of remote real-time biometric identification systems in public spaces for law enforcement purposes. And this is also a problem, legal problem to solve in Poland. What does it mean? It is planned by European Union to prohibit using biometric data like facial image with some data databases that are referential and collect them, compare us to identify some people in certain places. There is in this draft, the draft of this regulation, it gives a limited exceptions to this prohibition. When we're talking about targeted search of for victims of crime, including missing children, preventing a specific serious and imminent threat to the life or safety of individuals, or a terrorist attack. Also, when we're talking about detecting, locating, identifying, prosecuting perpetrators or suspected perpetrators of the most serious crimes, such as, for example, participation in criminal organization, terrorism, human trafficking, murder, rape, or child pornography. Still, there is an ongoing discussion about those proposals, and now we can see that there are some proposals also for amendments that are emerging. Some groups propose to total ban on biometric surveillance systems, including use after the fact and also used by private actors. There is a proposition on ban on predictive policing, that is using big data analysis of risks in specific places like in large cities. Also banning the use of artificial intelligence for risk assessment in the area of migration. So as we can see, to sum up, in Poland, many needs related to artificial intelligence that affect public sector, also the criminal justice system, law enforcement. Some of those issues are related to homeland security, some no, but due to the fact that not only in Poland, but also in Europe, there is a lack of legal regulations, the discussion on the use of AI in criminal law, I think, is alive. Therefore, I think also that the work of our team is very much in line with this current trends, and we will be probably able to formulate some answers to those current needs. I think in the next seminar, I will try to introduce the issues of those legal regulations and also good practices that are in relation to policing and criminal justice. But for start, this is what I wanted to present to you to show you how those needs are formulated in Poland. Thank you very much for your attention, and I wish you a great discussion and interesting topics next time.
Thank you very much for your presentation. Are there any questions for the speaker? I don't see nothing in the chat box. So if there are no further questions, I wish to move on to the next presentation entitled Debates and Private Law Research in Hungary related to artificial intelligence, that will be presented by Professor Emond Veres. Professor Emond Veres is a professor of private law in Miskolc in Hungary and Cluj in Romania. Currently, he is also head of private law department of the Ferenc Madl Institute of Comparative Law. Professor, you are welcome to present your research.
Thank you very much, and good afternoon again. And it is possible to see my presentation?
There is a problem. It is very small. Oh, now it's good. Now it's okay, but slide share should be on. We see the...
It is visible now, or?
It is visible, but now not in the share slide view. Okay, now it's okay. Now we can see the presentation.
Yes,
so please, the floor is yours.
Yeah, thank you very much, and I am very grateful to have this opportunity to discuss about the current status of debates and legal research in Hungary about artificial intelligence. Of course, I teach civil law, so my perspective will be of civil law, and I want to give you an overview of what is happening today. And I have to say that a lot of debates are ongoing in different fields of law and also in private law. And I will tackle today some of those debates in the Hungarian legal literature. Of course, all of these debates are connected to very practical issues, and some of them even urgent issues. So I will speak about the definition of AI from the perspective of private law. Of course, there is an ongoing debate on how to tackle the AI as an entity, and in this, from this point of view, there is a debate regarding the technological person of AI, or future legal personality of AI. And of course, main topic is always liability for harms caused by AI. And all of these are present in the Hungarian legal literature. So in general, we can say that the Hungarian legal literature presents a high degree of interest in the possible effects of AI in the development over the fields which are considered of private law. And simple research, a simple survey of the Hungarian legal literature for the last 3 years showed that in one of the databases of Hungarian scientific literature showed that there are a lot of papers and on different topics related to artificial intelligence. In the first place, of course, there are topics related to criminal law, but in the second place, there is the topics which are related to classical fields of private law. So these are just some of the main legal journals which were publishing in the last years about artificial intelligence. Of course, if we open to the technical issues, the number of articles will increase to hundreds, actually. And of course, we have to mention also just one of the most recent research endeavors, which is worthwhile to mention. It was of the Hungarian Academy of Sciences Artificial Intelligence National Laboratory, which engaged in a research project with the title of Challenges Posed by the Legal Environment of AI. And this research had some interesting outcomes as well. So in general, there is a living question that how the legal environment and the AI interact. AI, how can be integrated into the regulation, how it can be accommodated, and even some projects were proposed by different working groups, and all of these are concentrating both on the opportunities given by this technology and, of course, the risks which are inherent to this technology. And in general, I will address some of those questions raised today by the legal literature. As I said, defining the AI as a quasi-entity, and AI, robots, and civil liability. Let's start with the issue of definition of AI in short. And this is a very important issue because such a definition is practically needed because we are in a lack of clarity which is a phenomenon which can be included under the notion of AI, and which are outside this notion. And any lack of clarity on the meaning of the very notion of AI will render coherent legislation practically near impossible. So in this context, we should concentrate on the legal definition of AI, and we can find even in prestigious journals confusions made by authors, for example, between smart contracts and the digital ledger technology, blockchain, which is something very different from in comparison to AI. So this also underlines the need for definition. And I don't want to go into details, but in a written form of the presentation, I will show such cases when smart contracts or blockchain technology is considered as AI, which is for sure not. How we can define the AI, and in the Hungarian private law were proposed three approaches in line with the international literature. And the first possibility to approach the AI is defining AI as a software, and practically as an object to copyright, and taking the perspective of the owner of such rights. And practically we can say that the Legge Lata in the present regulation, this is the case. However, this approach is antiquated and fails practically to recognize that the AI is capable of actions not envisaged or not intended by the programmer or by the copyright owner. So AI it's a dynamic entity, unlike a book which contains also information. AI is dynamic. Second possible approach is to define AI as an immaterial asset, which is much more in line with the current approaches and technological realities. This, however, raises fundamental private law problems, because this would make the AI subject to real rights or a status assimilated thereto. And however, AI it cannot be a subject suitable to possession, as in the terms used for real rights. So AI must be considered a sui generis asset or a good sui generis good. And the first and the most debatable issue that can the AI recognized as an entity, as a legal person, as a subject of civil law rights and obligations. This is a debated one, and there are arguments enshrined pro and contra from several sides. So this is an important issue, because the consequences are reflecting on the whole regulation of artificial intelligence, and at the present state of development, maybe the definitions which are coming from the second way of approach are the most acceptable. Another issue, and I will shorten as possible the presentation to respect the time frame. There are the issues related to AI as a quasi entity, and this shows that the very notion of AI interacts on the level of legal regulation, that the definition has consequences on what we consider from legal point of view AI. Of course, the Hungarian legal literature has a lot of debates on this question, and we can say that we have this Cheshire Cat model from the Lewis Carroll novel Alice in Wonderland, which practically considers anything can be a legal person if the lawmaker considers that. So we can very easily say that AI is a legal person, technological person, was the notion proposed in the Hungarian legal literature, and the will of the legislator is the only factor which is the basis of the legal personality of AI. But this is a problematical issue, and it is discussed based even on philosophical considerations, legal considerations, and this approach is also very incipient in the comparative legal approach. So it's too early to have a final say on that, if AI can be considered a person or not, even if outside Europe there are signs that there are legal systems which are open to consider AI as a technological or legal person. And of course, the main issue is the civil liability, and this was discussed mainly in the highest number of articles. discussing objective liability and damage caused during dangerous activities, which requires this measure of objective liability. And practically, this is the most living field from private law perspective for debate. And there is the basic question is that, of course, there is a human liability behind, but by implementing just the human liability behind the AI, how we can solve this question? Will be liable the beneficiary of AI, which is practically end user, or we should go back to the programmer who created the AI, the company who created the AI, and we should also check the liability of the supervisor of the technology. There are very complicated questions raised by the international character of the globalized market. Maybe the producer of the AI which caused harm is outside of the country, outside of the EU. So all these aspects must be tackled. So it is hard to find a balanced and just solution. For example, just to say that the person operating the AI or implementation of AI on his own purposes, this is the only one liable. And of course, we should think about also implementing an insurance system which makes the practically the whole liability system functional, one avoiding burdening the end user in all cases with excessive liability, and in many cases we cannot reach the company which created the AI, for example. So just as a conclusion, all the main questions present in the international legal literature are present in the Hungarian legal literature as well. So we can say that it is up to date, the debate, and of course in many cases we don't have a final say, a final solution. Practically the debate is ongoing, and I am very happy to participate in this research, and maybe to at least to research on these issues, and maybe we can concentrate on the crystallization and make some little further steps in understanding the development of AI regulation in the near future. Thank you very much.
Thank you very much for your presentation. Are there any questions for the speaker? If there are no questions, I wish to proceed to the next presentation entitled Challenges to the Codification of Administrative Procedure in the Regulation of Artificial Intelligence. The presentation will be presented by Professor Hayas. Barnabas Hayas is an associate professor at the Constitutional Law Department of Pázmány Péter Catholic University, Faculty of Law and Political Science, and a judge at the Supreme Court of Hungary. Formerly, he worked in different positions at the Ministry of Justice of Hungary, and at the Hungarian Ombudsman Office. Professor, the floor is yours.
Thank you very much. Before the seminar, my computer froze when I started the PowerPoint, so I will give my short lecture without my presentation. Thank you very much for this opportunity to talk about some of the challenges of the codification of administrative procedure law. Please allow me to give a really short, brief overview of the reasons for the adoption of the Code of General Administrative Procedure in 2016. It is interesting because in 2016, exactly 4 years before the adoption of the new AI strategy in Hungary, it had to be regulated the new administrative procedural code. The new Hungarian strategy about the AI is a pillar or a main goal is the development of the e-administration, or exactly the using of AI solutions in the administrative procedures from data-driven technologies until the fully automated solutions, decision making, and so on. But we had make the regulation before this really important policy paper or strategy document. The new procedural code is aimed at renewing the administrative procedure law by ending the permanent modification processes that has characterized the past decade, also aimed at the establishing procedural institutions that enables the rights of clients or parties to prevail, ensures a more predictable law enforcement, and at the same time promotes efficiency and concentration of procedures. The new act, or I can say the old, because it is 6 years old, the act has several new features in comparison to the former act. It settles a shorter, simpler, more transparent regulation. It confirms the primacy of the code towards special procedural rules, and it ensures automated decision making. This is the point of my my presentation. So-called summary proceedings and priority of administrative arbitration in the legal remedies, the control of as a judicial control of administrative decisions. Further innovation was also the consistency with the government's efforts to reduce bureaucracy and facilitate a faster closure of cases. Before the new Code General of Administrative Procedures, was a perception from the government and from the citizens also. The administrative procedures are really complicated and are really long. We had a survey in this time, in the preparation time of the new regulation, and the data, the statistics were a little bit other result, because the most of the administrative procedures were also before the new code in 60 days closed. So not so long as the citizens or as the government it predicted. As I mentioned, in this code, we regulated first time the automated decision-making processes. It's good to know that in this system, we have three different way of procedure. Automated decision-making, so-called summary proceedings, and so-called full hearing procedure. The Code of General Administrative Procedure defines the types of proceedings, distinguishing between the summary proceedings and the full hearings proceeding. Moreover, as a special method of so-called summary proceedings, the automated decision making. These automated decision making and summary proceedings are essentially procedural forms that can be used in case of simple assessment, where the fast closing of the case is possible if its other conditions are met. The full hearing, in contrast, the classic way of the administrative procedure, in which all procedural actions can be carried out. So this is the traditional way of the administrative procedure. An automated decision-making procedure applied if there are four topics. The decision does not require deliberation. There are no adverse party. All the information necessary for the decision is available for the authority, for the administrative authority, and it is expressly permitted by law or a government decree. The automated decision-making procedure is specified in another law. It's called General Rules on Electronic Administration and Trust Services, and it's Section 11 regulates this automatic electronic decision-making procedure. It says an electronic administration organ shall proceed using automated decision-making where the relevant statutory conditions are met. When using automated decision-making, electronic administration organs shall pass and communicate to clients, the parties. In Hungary, the clients has a different meaning as in English, so we can name also as party their decision without human intervention on the basis of available data and data obtained through automated information transfer. It's really important that in automated decision-making proceedings, commencement application, clients shall submit their application following electronic identification using an electronic form provided by the electronic administration organ, so authority concerned. It's also important that the electronic administration authorities organs shall publish the methodology and material rules of the decision-making procedure applied in a manner that they are accessible both on their website and on customizable electronic administration user interface. So from these rules, it's clear that in Hungary, the administrative procedures can use the automated decision-making processes or the procedures if the technical and legal requirements are fulfilled, and after the law on electronic administration and trust services, we can clear see that the electronic administration procedures, exactly this fully automated procedure, must be also transparent. This is this way to publish the methodology and material rules of the decision-making procedures. The transparency of these procedures is only one of the important issue. The other one is the trust in the automated decision-making procedure, and that's way it's really important innovation of the code of general administrative procedure. This law has a innovation that in the case of an automated decision-making procedure or a so-called summary proceeding, the client may, within 5 days following the delivery of the decision, request the authority to conduct his or her application in full hearing. This is, on the one hand, as a new procedure conducted quasi by virtue of authority's office, but on the other hand, it is intended to prevent the court from examining only facts. The authority may be able to correct and support remedy and any mistakes or anomaly. I think this does not affect the finality or legal force of the decision. However, in case of objection of violation of rights, it is possible to examine the case more carefully. And I think the citizens need to know that their cases will not handled only by a computer or by a black box. Can before the legal remedy, before the court application, controlled or examine the case by a human person. It's also, in my point of view, it's important that the question, can it be determined from the text of the laws? Which technology, for example, deep learning, machine learning, expert systems, RPA, it applies to? In my opinion, clearly not. But that was also a goal, or I would say this was exactly the goal. In this, this related to the level of abstraction of the codification. We prepared, or I can say, we wrote this code not for half years, but a much longer times. And this was one of the goal from us, a little bit higher higher level of abstraction of the text, and it was also the goal some neutrality of the systems. In Hungary is also a scientific point of view, for example, from Erzsébet Fejes and Ivan Futo, that it is not possible to make an administrative decision with fully automated AI-based decision making, as the decision has to be justified and documented in public administration code, article 81, and they things these administrative procedures, machine learning system, which operated as black boxes, are unable to directly specify this requirement. As I mentioned, the code about the electronic services and trust service, electronic administration trust services, has an important rule about the publication of the method of the decision. Therefore, I think there are no black boxes, and these decisions are able to control. As I mentioned, when these laws were adopted, the database decision-making procedures and e-government mean something else. I am sure that the regulation is completely technology neutral, and as I told, they are also transparent. But there are some questions. What are the role, or how can a really good the legislator assigns to artificial intelligence in public administrative procedures? I think we have several roads ahead us or ahead of the regulation. Sorry for this before us, and we wrote because I was the leader of the codification group from the General Code of Administrative Procedure. So I can name this code also as a child of mine. So sorry for this really private formulation. So there are several roads ahead of regulation. For example, extension of fully automated decision-making procedures, and this can be a way for or towards for the simplification of administrative procedures, can be a way for the elimination of some technical and some administrative barriers from the administrative digitalization of administrative procedures.
I'm very sorry, dear professor. I would like to kindly ask you to summarize your speech.
Oh, this is my last 3 sentences. Sorry. development of so-called expert systems. They are background system for the decision making, and a way can be for the AI the automated customer support. And thank you for your attention, and sorry for my my longer speech.
Thank you very much for your excellent presentation and speech. I don't see any questions in the chat, so we can move forward. For the next presentation entitled Attempt to Codify the Punishability of Artificial Intelligence in Hungary, I would like to invite Professor István Ambrus. Professor is an associate professor of criminal law at the Eötvös Loránd University in Budapest. He has been teaching criminal law for almost 15 years. During this time, he also worked as a public prosecutor for 7 years and as a senior advisor of the Hungarian Supreme Court for 3 years. Professor, the floor is yours. You have 15 minutes, so you don't have to be in a hurry. You can share your screen.
Thank you very much. And welcome everybody. I'm going to share my screen now. Please let me know if it's appeared on your screen or not.
Okay. There is one question on the chat, so I would like to kindly ask Professor Barnabas Hayas to write the answer in the chat box, okay? If it's possible, it would be great. I can see your presentation, so the floor is yours.
Okay, thank you very much, Professor. And again, welcome everybody. There were several quite interesting presentations previously. Now, during my lecture, I would like to share with you some specific knowledge about the criminal lawyers' point of view according to artificial intelligence, especially for the fact that previously, 2 years ago, in Hungary, there were a committee organized by the government to analyze how to codify the possible punishability of artificial intelligence. And finally, as I was a member of this committee, we made a suggestion. However, it's not introduced into the recent criminal law yet, but still it's probably going to be interesting to talk it through, especially because it probably, according to artificial intelligence, we will have to rethink those dogmatical issues in the criminal law, which are actually all the same since the first Hungarian criminal code, the so-called Csemegi Code, came into force in 1880. So just 150 years later, we have to rethink those basic elements of the criminal law, just like, for example, self-defense or the regulation of the perpetrators. Okay, let me just start with a general point of view. Of course, in the European Union, in the last few years, there were debates about artificial intelligence, how to regulate it, and how should the member states deal with artificial intelligence. And as far as I know, since then, of course, there were more development also. However, in 2018, there was a definition for artificial intelligence, which actually stated that artificial intelligence refers to systems that display intelligence behavior by analyzing their environment and taking actions to achieve specific goals. Let me show you the most important general features about artificial intelligence, which is actually the autonomous working, which means that during the work of the artificial intelligence itself, the so-called deep learning technology used to make unpredictable outcomes by the artificial intelligence, especially when we're talking about the criminal law point of view, as I will mention some examples, like the problematic of self-driving cars. As we will see, can we even talk about a driver in a case of a self-driving car, especially if the person, the human being himself or herself, who just sit in the car when an accident come about, can we punish this person, this human being, because of a traffic offense which was actually committed, at least in a hypothetical sense, by the artificial intelligence itself. Okay, of course, criminal law is strongly related to philosophy, and of course we have to mention the philosophical background. As actually Descartes stated, machines cannot express their thoughts, also machines cannot act consciously. However, Professor Dreyfus, just a few decades ago, also stated that a robot, an artificial intelligence, cannot be ever considered as a human being in a philosophical, legal aspect. However, nowadays, since the artificial intelligence technology extremely getting in our everyday life, probably we should rethink this issue also. Just to show you the framework of legal responsibility, of course, if you're talking about the branches of law, we have to talk about, of course, the constitutional aspects. However, if we're dealing with responsibility, we have to make a distinction between the civil law aspect, as Professor Veres already mentioned, and also the criminal law aspect. In this kind of separation of the branches of law, our opinion is that at least in a theoretical sense, for the criminal law, it's a much harder task to somehow establish the criminal liability according to artificial intelligence, because in the case of civil law, there are a lot of legal institutions to establish the criminal liability. Just to mention product liability, which is a kind of strict or in the Anglo-Saxon expression, it's a kind of corporate liability. So we can establish this kind of liability even in the lack of the personal guilt of the perpetrator. It could be somehow similar in the labor law. However, at least in the classical sense of criminal law, we always need a human being, a perpetrator, who should be punished according to his or her act or omission. There are several issues, of course, according to the substantive criminal law. However, as you can see, I'm going to only talk about two issues today. Of course, in the time issues. First of all, who can be considered as the offender, the perpetrator of the artificial intelligence crime, and also if the artificial intelligence itself cannot be punished, then who can be blamed if some kind of harm will exist according to the movement of the artificial intelligence. Of course, there are several other issues, the obstacles of criminal liability, which is a quite interesting and important issue, because as far as I know, especially examining the possible regulation of self-driving cars, there are so many scholars in the literature who actually states that the first the first pre-question should be, do we even need criminal law in the case of the self-driving cars? Because there's a risk, of course, in every new technologies. However, if the technology of artificial intelligence as self-driving cars will we can avoid those accidents, which are actually nowadays related to human beings, then we should overthink if we should punish anybody if a fatal accident would come about according to an error of the artificial intelligence. Of course, the criminal offenses, as I will share with you some of those issues later, and finally the sanctions, which should be, at least in our opinion, quite similar to the framework of the punishability of legal persons. Of course, a legal person, a company, cannot commit a criminal offense itself. However, if, for example, the leader of the company was punished, or even if there was an obstacle, just like the death of the perpetrator or any other obstacles, then the legal person can be punished, at least under the Hungarian criminal law, on its own. Okay, let's check those issues according to the offender of the artificial intelligence crime. As I already stated, in the classical meaning of criminal law, we need a human being, and the society, of course, would like to punish this person according to his or her act or omission, which was actually dangerous for society. So we need the natural person who commits the criminal offense, and finally the prosecution and the sanction will be imposed mostly by the judge. The problem, of course, arises if there's no human action who can be punished instead of this person. Of course, you're talking about the dogmatic point of view of the criminal law. The conduct which will be punished is always a human. Of course, if a human uses an animal, for example, to commit the criminal offense, it will be also considered as a human conduct. However, in the case of artificial intelligence, we cannot talk about conducts, so we should somehow rethink this definition of the conduct, at least if we would like to punish the artificial intelligence itself. However, in the previous literature, Locke and Kant also stated that the robot cannot be punished. However, in the United States and also the literature in Germany, Professor Weygand and his co-authors stated that at least nowadays we cannot punish the robots because, of course, an artificial intelligence cannot understand the meaning of the punishment. However, in the future, there could be probably somehow establish the punishability of the artificial intelligence. Okay, if we cannot punish the AI itself, then we should seek for a person to punish. This in the Anglo-Saxon literature, the man behind the machine doctrine, which would like to punish, of course, a human being who is behind the artificial intelligence. It could be the user, the programmer, or even the owner. In the Anglo-Saxon legal system, no need for criminality, there would be movement of a human being. However, in the continental legal systems, it's quite strange yet. So we need causality, the intention or the negligence of the perpetrator, and also the owner would be a legal person, which is also debatable how to establish the criminal liability in those cases. Of course, the manufacturer could be also punished, but it's the fact that the criminal law, if we consider it just like we used to, cannot get to this base, because it's actually just like the private law approach. However, in the last few decades, private law and criminal law getting closer and closer to each other, but of course quite not the same. Okay, now the models of criminal liability. We cannot punish the AI itself. we could punish the owner or the programmer, or in the case of the self-driving cars, the driver of the self-driving car. We could have an approach called the command responsibility, which is just like if a soldier commits a criminal offense, it's not punishable if it was committed because of a command. And finally, the natural probable consequence liability model, which is also strongly related to the private law approach. Okay, and finally, let me show you two examples from the suggestions which were stated by the before mentioned committee, which aim was to somehow amend the Hungarian criminal code according to artificial intelligence. We dealt with the definition of the perpetrator. In the Hungarian criminal law, we have a direct and an indirect perpetrator, and we have the so-called joint perpetrators. From these three, we suggested to amend the definition of the indirect perpetrator. Indirect perpetrator is similar to the abettor. However, in the case of the abettor, the person who was used to commit the criminal offense is also punishable. In the case of the indirect perpetration, for example, if an adult use a child to commit a criminal offense, or use an insane person to do so also. Our suggestion was to introduce into the criminal code if the indirect perpetrator use not a human being, but a so-called autonomous decision-making information system to commit the intentional criminal offense. And the other suggestion, the case of the justifiable defense, or in other words, the self-defense, which tool to security in the cyberspace. We would like to introduce this new regulation if an unlawful attack against an information system directed against one's own or others' property, or directly settling them, is possible under a separated act, which means that our suggestion is we should introduce a brand new model code to regulate all the issues about artificial intelligence. But sometimes, of course, a so-called blanket law in the criminal law is also needed, which will be filled up with this before mentioned separated code, and it would somehow regulate in detail how can we use the artificial intelligence to protect our property, for example. And of course, finally, we should also consider the issues about the special part of the criminal code. There are two kind of solutions. We should probably introduce new so-called sui generis offenses. There was a suggestion to introduce the so-called information terrorism into the code, and also we could somehow make wider the legal interpretations in the code to make it comfort with the autonomous decision-making information systems, just like to consider using artificial intelligence as a profession. So then the so-called endangering using a profession as a separated criminal offense could come about. And because in the lack of time, thank you very much for your attention. And if you have any question, do not hesitate to ask me. Thank you very much.
Thank you very much for your presentation. The last presentation will be presented by myself, and the presentation will be on the status of research on the legal regulation on artificial intelligence in Poland. Due to the fact that our time has already run out, I will very quickly and synthetically present my presentation. And to do that, I will share my screen. Sorry, I cannot sharing my screen. I can, okay. Do you see my presentation and if it's visible enough?
Yes, we can see the presentation.
Okay. I have prepared for you a short bibliometric review on the presence of the concept of artificial intelligence in legal regulation in Poland. I think there is something wrong with internet because it's not skipping. Okay, it's working. The phrase artificial intelligence was found in 28 legal acts published in Journal of Laws or Monitor Polski. According to legal databases. I will disclaim right now that I analyzed only publications on legal, I was analyzing only legal aspects. So I was using the two largest legal information systems, that it's the legal information system LEX and Legalis. Of the indicated legal acts, only 12 are currently in force. In Poland, there are no legal acts at the statutory level that define artificial intelligence, regulate the applications or liability of artificial intelligence. The phrase artificial intelligence appears in one statute only. On the Future Industry Platform Foundation, the phrase artificial intelligence is present in 15 regulations, only 5 of which is in force, the majority of which relate to the program basis, teaching standards, and qualification procedures. And the regulations defining the program basis for pre-primary education, primary school, general secondary school, technical school, and upper secondary school, artificial intelligence is only indicated in the content of ethics teaching. The phrase artificial intelligence is also mentioned in the regulation on academic computer network tasks, and the tasks of the NASC include also the implementation of scientific research results and the conducts of development work supporting machine learning and artificial intelligence. The phrase artificial intelligence also can be found in the strategic and program documents. Of key importance is, of course, the policy for the development of artificial intelligence in Poland. And the artificial intelligence policy adopts as its own the definition of AI according to OECD. This definition was, I think, referred today before, so I will just skip it because the lack of time. This slide we will also skip. And what problems I can see? What are the strategic factors building the potential of Polish artificial intelligence? What are they include? Data, knowledge, competences, skills, qualifications, funding, infrastructure. I can only ask where we should have law and research on that subject. So we can also see into the framework for the Polish AI ecosystem, legal dimension, and we can find some indicators of policy orientations. Of course, there is also legal definition of AI included. I also analyzed case law and scientific publication published in Poland on the subject of artificial intelligence. I will disclaim, of course, once again, that I analyzed only publications on legal aspects, having under consideration the goal of our research. Therefore, I use legal databases, Lex and Legalis. So what can we say about this? These publications are not many, comparing with other publications on new technologies. In the scientific bibliography of the Polish Academy of Science, I found only 108 scientific publications on artificial intelligence. A part of them are chapters in collective monographs. There is no judicial case law on artificial intelligence. The phrase artificial intelligence appears only in those judgments that are referred to public procurement procedures for systems or applications in which the use of artificial intelligence was projected. Here is one example. So because our time has finished, turning to a synthetic summary. First, there is a lack of even residual legal regulation of artificial intelligence and its applications. The national legislator has used the concept of artificial intelligence several times, but the term has not been defined. In the indicated core curricula for schools, the problem of artificial intelligence appears only in ethics classes, in ethics studies. The number of scientific publications on the legal problems of artificial intelligence is very small. It should be noted, however, that the last 2 years have been published collective monographs that analyze selected legal problems of artificial intelligence. There is no judicial case law on artificial intelligence. As a prosecutor, I'm personally extremely interested in the criminal regulation of artificial intelligence, both in terms of the problems of criminal liability for the operation of artificial intelligence, liability for faulty preparation of the algorithm, or defects related to the learning of artificial intelligence, for example, through fault selection of data for learning algorithms. The cybersecurity of artificial intelligence and its use by cyber criminals is also I think, extremely interesting area of research for me. Unfortunately, the Polish literature on the criminal law aspects of artificial intelligence is very narrow. I think the research we are conducting can therefore fill an important gap in scientific research. So because our time is finished, I'd like to ask you if there are any questions. I will just close the sharing my screen. If there are any questions, there is a discussion. There is a discussion on the chat. Okay, but there are some answers also. Because our time is finished and it's very late, I would like to thank you for attending our team's first scientific seminar. We warmly invite you to our next seminar, which will be held on 26th of July and will focus on international regulation concerning artificial intelligence. Thanking you for attention. I wish all the speakers further fruitful research and all of you an enjoyable afternoon. So see you on 26th July.
Thank you very much. Goodbye.
Thank you.
Thank
Goodbye.
you.
Thank you and bye.